So just go down to the clerk's office. God bless my clerks. Some of them will help you. The majority of them probably won't, but you might find a nice one. And the reason why is not because they're just rude or they don't want to help. They don't want to be responsible for anything they told you wrong, and you file something, you get there and the judge is like, what is this? And the first thing anybody's gonna say is, well, the clerk told me to do this. So, you know, be patient with them. Some of them, nobody wants to be responsible for anything that comes in front of a judge and is not done properly, or you didn't take their direction properly and now they're blaming you. And you gotta understand from the judge's perspective, even as a young attorney, I would always think like, this is my case, I know everything that's going on, but these judges are dealing with different issues all day long, all month long. It's another case in front of their face. So they're going to things that pop on the paper. And like Kris was saying, dates, times, locations, what they were wearing, so they know that you're just not making the stuff. So in my opinion, what a lot of lawyers look at reasonable doubt is like 99%, like this person did not do this, and we have a 99% reason. This is why it's reasonable, because we hit everything that could have possibly happened. And the key word I love there, that's why you gotta listen to like lawyer jargon, because the words mean something. Reasonable doubt. We might have some doubt, but like, it's not reasonable, bro. Like, it's not reasonable.
Being in the real estate investing business since 2004, I've been to court dozens of times. In fact, I'll show you on the screen right here some of the court cases that have been filed. And I've been so blessed and fortunate to have won every one of my court cases. So today, I would like to share with you the things that we have done in our court cases to win in court in front of a judge. And we've got attorney Jeremy Mason here with us to explain to us the steps and the mentality and how to set the tone when you go to court, just in case you don't want to have to hire an attorney for each time. And you could hire an attorney if you want to, but today we want to kind of give you the outline, the bones to go into court and win. Let's do it. Okay, class, it's Kris Haskins with therealestateroundup.com. My mission and ministry is to raise your financial literacy through real estate investing and entrepreneurship. So being an entrepreneur, there is bound to be a time, and a real estate investor, that your butt is going to be going to court. Would you say, Jeremy?
Absolutely. It's not like if, it's normally like when. You know, that's like to tell people, it's not if it's going to happen. If you're doing your business the way you're supposed to, you're doing a lot of transactions. Unfortunately, you're going to have these hiccups. So just be ready whenever that happens. And I'm here to help you guys with that process.
That's right. It is going to happen, y'all. So this video, we want to kind of help you guys unpack going to court. And Jeremy is a master. He is a real estate attorney right here in the Hampton Roads area. And he's going to help you guys navigate going through and standing in front of that black robe.
Exactly, the black robe, yeah, because that's a foreign place to most investors and business owners. That's the last place you want to be. So when you get there, it's kind of like public speaking. All of us aren't the best with that. So you want to have all your ducks in a row. And what I like to tell people that I know, and more so what I do for my clients, is we want to set that up before we even go in the courtroom. When I say that, I mean like, for instance, before you even have to feel like you have to file a lawsuit, let's get our contracts together properly. Let's make sure our lease documents are together properly, whatever contracts you're doing, joint ventures, purchase agreements, all that is squared away to where if this issue does happen, that's the flow of the conversation. We're just going off the contract, we're going off the agreement, no discrepancies, no outside agreements or conversations like, Your Honor, here's my lease, here's my document, and here we go. But from there is kind of understanding the landscape of where you're going to file these lawsuits at.
Okay.
So for our conversation today, for our investors and people handling it on their own, majority of you all are going to be in either general district court or small claims court. Small claims court is anything up to $5,000. That's where you're going to have like your, deposit issues, possibly security deposit issues,
small down payment,
anything that's involving that number is going to be there and lower. And a lot of times, people handle that on their own because Obviously, once you get an attorney involved, there's attorney fees. You can ask for those back, but the attorney fees kind of like, does it even make sense to get a lawyer involved to get this? If I got to pay him half or maybe more, or maybe even more than what I'm looking to get back. So you got to kind of gauge that as a business decision. But a lot of times, like small issues, people take your property, damage your property, and you're like, well, what can I do? I mean, we don't want you to go beat them up or just change the locks. Just
street justice.
Yeah. No self-help. That just blows it all the way up, and now you got a problem on your hands. So just go down to the clerk's office. God bless my clerks. Some of them will help you. The majority of them probably won't, but you might find a nice one. And the reason why is not because they're just rude or they don't want to help. They don't want to be responsible for anything they told you wrong, and you file something, you get there and the judge is like, what is this? And the first thing anybody's going to say is, well, the clerk told me to do this. So, be patient with them. Some of them, nobody wants to be responsible for anything that comes in front of a judge and is not done properly, or you didn't take their direction properly and now they're blaming you. So they're probably not going to help you, but they might kind of like give you a couple nuggets, but they're not hard documents. Warning debts, it's laid out for you right there.
Is warning debt the coast to coast or just in Virginia?
Just in Virginia, yeah. Warning debt in Virginia, some jurisdictions are going to have their terminology, but it all kind of flows from the same thing. So you get that. And this is another big thing I would say. A lot of people, when you get into the game, you have an LLC that you have, and then you have yourself individual. Like, so Kris Haskins has his LLC. You want to make sure whatever that lease says is you're going to be the plaintiff in that scenario, whether it's you, the individual, or you, the person, your entity, your business entity. So that's one way that thing can get kicked out, is if you go in there saying, I'm filing it for myself individually, but your documents are in your business name. So make sure you have that distinction there, because that's one way for situation to get kicked.
How should they handle that?
I mean,
file whatever document is on there. Unpack that.
Yeah. So again, let's go back from the beginning. The lease or the purchase agreement. So if you say this is
the lease.
Yeah. So the lease. So this agreement is with Waze whatever LLC, and then you have the individual living in the home. That's the tenant. So there's going to be, your lease agreement is going to be set up like that. So if they do breach it, then that's when you look at your lease and see who is the individual that's taking the tenant for rent each month, and this is the person that you're going to be taking to court. So that's knocks that out there right there, and you can understand that process. Yeah. So from there, I mean, that's kind of what's going to flow.
We started at 5,000.
Yeah.
Before we leave that, Jeremy, $5,000 used to be a lot of money.
Yeah, it used to be.
You with me? So I remember back in the day, my security deposit was $850. And my rent was $850.
Correct.
So if they missed 4 months rent, I was still good under there.
Yeah.
But now, Jeremy, my security deposit is $2,000, and then my rent is $2,100.
Yeah.
Do you think that our municipalities might be raising that soon? Because it seems like $5,000 is not even.
Well, then that's when we're going to get to probably the next level, because I think they have this covered with the low general district court. $25,000 is the max there. So you're going to be in general district court asking for these amounts. And at that point in time, they're probably going to be in breach of the lease. And a landlord, is always good to have a tenant, but you don't want to have a bad tenant. So at that point in time, you might be asking for possession. So this is something that has changed. I know a lot of you guys aren't Virginia, but Virginia specifically, if you are and you're listening, when you sign up for these leases, there's one document that you want to make sure that you have is the tenant's rights document. You got to have that. God. And that's fatal to any claim going into court. And it changed in 2024. So a lot of people don't know this. So you have a lease that you started in 2022, and all of a sudden they're not paying it. Then you go file it, and you think you got everything in a row, you got all your ducks in a row, and then the judge asks you, oh, God forbid they have a lawyer, and the lawyer is, where's the tenant's rights? It's dismissed, just like that. And that's fatal. And that's just one piece of paper. And you'll think that, okay, well, what if they don't sign it? Because, people are smart. They try to get creative. Yeah, so now it's this dispute. So what if they don't sign it? Well, look, counselor, I'm going to tell you. Counsel will tell you that they're not going to hold up unlawful detainer and letting them stay there because they didn't sign a document. All you have to do is document the fact that you gave it to them. Yeah, you send it to them, you sign it. This is when you send it to them, but you have to do that part because they're not just going to let them stay there because they didn't sign this one document, but you have to let them know their tenant's rights. So tenant's rights.
Please, if you don't get anything out of this video.
Yes, that's a major one. A lot of people sleep on that. So now we'll switch to unlawful detainer filings. Yeah, you just want to make sure you have your lease.
Before you go, what it for our people that don't live in Virginia, because unlawful detainer means nothing.
Well, that's a good question. I'll be honest with you. I'm licensed in DC and I'm licensed here in Virginia, and that's the term that we use. But I'm sure that it might be a term of art. But I'm gonna say
eviction.
Yeah, eviction.
We gotta be clear. This is for an eviction.
These are for evictions. Yeah, that's a term that runs across
the board.
Really, probably across the world. Eviction. These eviction notices. So you're doing your evictions. You want to make sure you have all those documents in place. And though a lot of times you can maybe even ask the clerk that. They might give you what you should have, but they're not going to go any further than that. They're not going to go any further than that. So,
yeah, they won't let you hang yourself on documents, man. They've helped me out through the year. Not a lot, but they've helped me out. And you said earlier that we're not mad at our clerks because they don't get paid enough.
Yeah, clerks are underpaid, overworked, underpaid.
We love
them. Without them, we can't do anything. I love clerks. So if clerks listen to this, I love you. You help us
You
help us get from A to Z, and you guys are underpaid. I will say that, man. We got to talk to our legislators about those situations.
That's true. All right. So I got a whole bunch of stuff here. Go ahead. So, general district. When you said the first court was what?
Small claims court.
Small claims court. That's gonna be under $5,000. Then general district is
$25,000 down, unless you're dealing with a personal injury accident case, then that can go up to $50,000.
All right, so we probably won't be covering too much of that today. This is for the smaller stuff, because this is for my landlords and people that are doing business on a smaller level. I mean, you got a whole nother level. Wow.
Yeah, there's different levels to it, but I mean, these things are needed because nobody can live for free, so we're not doing that. So this is the process to free up that land for you.
Okay. You got anything else, Jeremy?
I mean, that's kind of really the gist of it.
Okay, cool.
I would say, I think we talked about making sure the lease agreements prepared properly, your contracts are prepared properly, so when these things happen, you already have everything lined up. We talked about knowing where you want to file at. Anything $5,000 or less, you go to small claims. Anything $5,000 or more, you're in general district court.
Okay.
You want to make sure you indicate exactly what you're suing for, whether it's for past rent or whether it's for a breach of the lease, like they changed the rug, they weren't supposed to change the rug, or they changed some locks. They did something that was a breach of the lease. Those are two different distinctions. One's going to be obviously past rent. Another one's going to be for breach of the lease. Those notices are different. Past rent here in the Commonwealth of Virginia is 5 days. Notice, 5-day notice.
They tried to change it, Jeremy.
Yeah, they did.
A few months ago.
They did. But make sure you have given their tenants rights before you give them the 5-day notice if you haven't already, because that's a big thing. Some judges want to, so the basis for that is the tenant's rights are just explaining to the tenant literally what their rights are in court and what they can do against the landlord, or they understand the position that they're in, because believe it or not, a lot of renters don't know what their rights are,
Which is not fair to me. Why do I have to make sure you know your responsibilities, Jerry?
Well, I mean,
nobody told me.
That's true. And a lot of times you are what I consider a good business person, but you have some of these landlords out here who aren't the best business people, and maybe some of them aren't the best morally correct individuals. So now they got the tenant in a whole box. They're
putting them in the trick.
Yeah, exactly. It's a trick box. So you want to at least want to let them know like what they're right. For example, I'm glad you brought it up. Like, so how does the tenant sue the landlord? And this will help you guys, the landlords in court too, because they didn't do this, and a lot of y'all know this. Is like tenants assertions. They say something's wrong with the property or something's wrong with the building that they're in. They have to do their tenants assertions. Basically, you still have to pay the rent, but they have to pay that to the court. So a lot of times they come to court thinking they have all the leverage because they don't have to pay rent because it's not properly done. That's not true. You got to pay it into the court through the escrow and make sure that's done properly. And then from there, if everything's fixed, then obviously the landlord will get the rent. And if not, then it goes to the court and they just move out. So those are things. Tenants assertions are very a big thing for tenants to understand that process when things aren't going right with the unit and it's not habitable.
Okay. They just pay the rent to escrow.
Pay it to escrow. You got to pay something. It's never a live for free scenario out here in the world. You just can't do that. Can't do that. And the people that think that you can't do that, I'm talking to you like, come on, like, what are we doing here? You got to have some accountability for yourself. Don't try to live anywhere for free, man. So
yeah, it ain't gonna work out good.
Yeah, yep.
So today I wanted to make sure we covered landlords as well as just entrepreneurs, because I do a lot of financing for car dealers.
Okay.
And sometimes the deal go bad and then I gotta go after them and stuff. So
Yeah.
I want people to understand that deals are going to go bad.
Yeah.
It's just the price of doing
we don't
it.
get into business for that, but it's like you got to be prepared. You know how you're going to go about it. That's how you can sleep well at night. Knowing your agreements and your documents are sealed, airtight, to where if this thing does go left, we know what we're doing. We have a recourse. If we're not hoping the person does right, we know they're going to do right. And if they don't do right, then this is what I'm going to get. I'm going to get the title to the vehicle, or I'm going to get the title to the home, or something to where the lender should always be good. There should never be gaps or like putting yourself in that bad position to where you have to go to court or anything like that, or try to take self-help, which I don't recommend to anybody. But there's this one thing I put into a lot of clauses and agreements for investors: confession of judgment, meaning that once you sign this document, we don't have to go through the normal process of serving you and going through the whole litigation process to show why you owe this money. You sign this. Once it's filed, we can give you notice through whatever means that's not exactly the service process, like getting a private process or the sheriff. We can send you an email, send you a text, and give you the date. And as long as we can show that we did that, the judge will see it, and then boom, he'll give you the judgment. And obviously, that's just the start of it. I mean, but the judgment in your hand is the judgment, but then now you got to collect on the judgment. So that's a whole nother conversation. But those are things you want to put those safeguards and those agreements to make sure that you're good and you can sleep well at night.
I like that, Jim. Repeat that again.
Yeah, confession of judgment.
Confession of judgment. I should use that one, y'all. That's why we keep attorneys around.
For sure.
Well, Jeremy, we hear, I always talk about, I'm going to sue, I'm going to do this, I'm going to do that. But then I guess I don't think the general public understands that, like you just said, it's just the start. Getting a judgment means nothing.
Yeah, and I won't say nothing. You got something. It's a piece of paper. That's what you have. You have a piece of paper saying this person owes you money, but they can't go out and get real estate. They can't purchase something like a massive purchase, like buying a house. They have to go back through you. They have to pay you before you do that. So you have something that's a safeguard, it's a stop, but ultimately we want money in our pockets. That's what this civil litigation is about. So like people have like their emotional feelings and they get all wrapped up. I'm gonna take you to court. But look, sometimes settling is not bad, because then first of all you got the money in your hand. You don't have to pay a lawyer. You don't have to stand up in court. You don't have to wait to get the money. You don't have to like do all that. So if somebody says, "Look, I owe you $10,000. I'll give you $6,500." I mean, you have to kind of gauge your business practice and what else you have going on. But if you can just get the money right then and there, I advise a lot of clients, just get the money, because take that, it's a loss, but you still have this and you have to go through all of that. And then you don't even know if you're going to get that or less when you go through all of that. So you have the money right there. Take the money, you're done with it. The courts are the last resort. And believe me, a lot of these judges, they have to help out the community and serve as the end all voice to this. But I mean, we're all grown. It's civil court. If we can work something out, by all means, work something out. That's always the best rule in my book. Let's work this thing out before we have to like really get down to it in the courtroom and then put people back in their place. Let's just try to work it out first. And then if that's the last resort, then you ain't got no other choice.
Got it. All right, I've got a whole bunch of things here, Jeremy. When I've been to court dozens of times, and I've seen people lose a whole bunch of times because they violated these things that we're going to go over here.
Yep.
Well, from my perspective, when I'm in court, you the attorney, let's start here. Judges like dates and times.
Absolutely.
Did you just start there?
Absolutely, yeah. Again, you got to understand from the judge's perspective. Even as a young attorney, I would always think like, this is my case. I know everything that's going on, but these judges are dealing with different issues all day long. All month long, it's another case in front of their face. So they're going to things that pop on the paper. And like Kris was saying, dates, times, locations, what they were wearing, so they know that you're just not making this stuff. Yeah. So the more descriptive that you can be, It helps out the court. It helps everybody out involved, and then it helps the flow of your case. So you're not just up there rambling and saying what you think is
Which
important.
is what most people are doing.
Yeah. They just because now I like the terminology is like you're just like shooting a shotgun at the wall to see what sticks. You're just throwing something to see what sticks. You don't even know what's important, what's pertinent. You're just saying stuff. So if you have these who, what, where, when's, and hows lined up properly, 9 times out of 10, all that's going to be hitting straight to the issue.
I have seen judges, Jeremy, look at me, and I can tell they want to hug me.
yeah, because you walk in there and you're not a lawyer, and you're hitting point. I'm like, this guy, and then now you're on the good side. So now the other person has to get back to just even because the judge is on your good side. You're on the good side now. It's just like everything he says, I'm just nodding his head like, yeah,
exactly.
I'm with you. Now I want you making my job easier. Now I want to make your life easier. And then the next person has to go against that. They might say some good things, and I don't know. And then if they say one bad thing, and it's over. I mean, so just keep in mind, we want to keep the judges on the good side for sure, and that helps them do that by keeping stuff lined up, organized, proper, succinct in your approach.
Man, succinct. I love that word.
Yeah.
Jeremy, when I start off, Your Honor, on May 1st, 2020, whatever, this started. I can see their face open up.
Yeah, they're gonna perk up. Because sometimes you can just tell the judges might be looking down. You say the right thing, they're gonna look up. They're gonna give you that. Okay, we're here now. You're not rambling. You're not just saying anything. You're actually trying to get some stuff done, and you put in work before you got in here. So now I have to respect you.
Okay.
Yeah, they can tell you put the work in before you got in there.
Got it. So that was number one I want to cover. So y'all, please, dates and times.
For sure.
The next thing was the parties involved. Who are these people to you, and what do they mean to the world? I mean,
okay. And then
explain that.
I'm gonna go back because the dates and time thing. I just want to give you this nugget. A lot of times people like to round up to 7:30 or 10:15. If you say like 7:28 p.m., that's like an extra one. It's like an extra thing. Like, it's
go down to the minute.
The minute,
okay.
Yes, the minute. You don't have to go to the second, but if you go down to the minute, anybody that's listening, that's just in life. If you say something down to the minute, they're gonna know like, okay, he's on it to the minute. So, What was your next question?
Well, I'm just talking about the people, the parties involved. Now we have our documents, obviously, but the judge wants to know who are these people, who are the parties involved with this thing?
Yeah, and helps them clear that out too. So, like we were talking about earlier about the contract or the lease agreement, you have the LLC, or it could be yourself, and then you have another thing. Make sure if it's multiple tenants, you have both their names there too, not just one. Multiple tenants, whoever's name is on the lease. They need to be on the lawsuit or the eviction forms or the unlawful detainer, however you want to put it.
Costs more, but
it costs more, but that's how you get it done. Because if you don't serve and file both parties, then the judge can't move forward on it on that day anyway. So it just saves you a lot of time and cost and frustration just to make sure you have everybody lined up, who they are. And then if you have to go into your arguments or trial, like how this person has affected you or how this person has affected you, it's have like a small little outline, but there's like 2 or 3 or 4 bullet points for each individual. And then you're going through your flow chart as you're talking to the judge, and everybody's happy because you're not rambling.
I love it. And I've noticed too, like how I even met them. I've had tenants, Jeremy, that another tenant put in, and I didn't have a lease with them. I had a lease with my guy.
Yeah.
So I had to explain to the judge, like, look, Your Honor, I don't know who they are, but this is how I met them. And he was extremely empathetic to the situation.
Yeah, because that's sublease. They're doing subleases without you knowing. I mean, those are key things that should have in any lease agreement. Don't give them the power that you have, because what you did to vet the person to get in there, they're not going to do that. All they're going to see is dollar signs. They're going to see dollar signs, and they don't care about the end game. They're like, oh, he's paying me and I'm paying the landlord. So create those sublease terms that you can't do that.
Okay, so locations. I have noticed that if I met somebody somewhere, I never forget I was doing a deal with a car dealer. I loaned them $8,000 to do this car. We were flipping a car, and I remember distinctly we met at the bank. I pulled the money out. It was 12 noon. We had just went to lunch, and I could see the judge like, man, this is the real deal. Location.
That's locations. Because again, it's your word versus their word. Even if you have witnesses, it's still their word versus their word. And some witnesses rank higher, lower, whatever. But if you can start to being descriptive as to what, like I said, the person, what they were wearing, what you did prior to, what you guys were doing during the conversation, the exact type. Say you gave him $4,000, I gave him $4,000 and all 100 bills, like things like that. The more detail you get, because what you're doing is you're painting a picture for the court, and you're doing two things. You're trying to put the trier facts. Most people that are listening to this are going to be judges, not juries, but you're putting the judge there with you in real time so you can see it through your eyes how this transaction took place, and then also you're creating more painting that picture of as to like what happened in the whole scenario. So
well, let's talk about what the judge too, Jeremy, because I learned as I was developing as an entrepreneur, there are two different barriers that we have to prove regarding criminal and civil, because this is all civil, right?
This is all civil we're talking at the moment, yeah.
So could you just break down for the people that don't know that there's even, I didn't even know the preponderance of evidence, reasonable doubt.
So there's three, so you hit on, so the criminal one that we all know, the fancy one is the reasonable doubt. And that
we don't even want them there. I don't want y'all here.
But I mean, because they're going to talk about percentages. So to me, in my opinion, what a lot of lawyers look at reasonable doubt is like 99%, like this person did not do this, and we have a 99% reason. This is why it's reasonable, because we hit everything that could have possibly happened. And the key word I love there, that's why you got to listen to like lawyer jargon, because the words mean something. Reasonable doubt. We might have some doubt, but like it's not reasonable, bro. Like it's not reasonable. Come on, we get where you're going with it, but that's not reasonable. So the reasonable doubt is really important. I like how they put that word reasonable there, because that just changed the whole game. Just that one word, reasonable. But the next thing is preponderance of the evidence. That's more civil. That's when you're dealing with your car accidents, these things of this nature, landlord disputes, whatever. That's 50%. So that's the whole lot less. That's just like getting half the way down the field. Like, look, this happened. This is believable, because we don't want to, at this point, you done got to that point, you have all your documents set up, it's clear what happened, and then you can prove it to this point, you got it, bro.
Preponderance of the evidence.
Yeah, preponderance, yeah. And the next one, that's 50%, preponderance of the evidence. We have enough to believe this happened. All right, we're good. Clear and convincing evidence, that's 75%. So that's where it's like, we got past preponderance, but we need something clear and convincing. And then that's when you get into like those contractor disputes about who did what and didn't do all that. You get like those big time, contract disputes as who didn't perform, those things of that nature. We need clear and convincing evidence that you proved your point, and that's 75%. You get there, we're gonna rule in your favor. So those three things are key. And if you do this on your own, think towards the end game. Is this enough to get me halfway through what I need? Did I start off with my contract, my lease right, to show the judge why? Do I have my list as to where I'm going to get to the preponderance of the evidence? Start at the end, and then from there, you should have no problem proving your case.
Y'all getting this. This is good stuff, Jeremy.
Yeah.
So phone conversations, a little bit about, I remember I was talking to this person on this day. It was raining outside. I remember it was something happened, a current event on the news maybe.
All that's great, because then now you're not rambling. You're actually making points. It's like every time you say something like that, it's like 1 point, 2 point, 3 point. You're trying to get to 50%. So you're getting all these points. You're driving it in there, all these points. But then the thing that people mess up is like they say too much, or they start going off of their outline. Now you're rambling. So you might even be losing points. It's kind of those things where it's like
certain much.
Yeah, you got to. And there's an art form to that. But again, you guys aren't lawyers, but I'm just trying to give you the game the best way I know it. So when you're in there, some of these things you might remember to know, like, okay, let me stay within my outline. Don't go too far. Just give them what they need, and then let's move on to the next thing. Yep. Okay, so Jeremy, I have never lost, thank God, I'm knock on wood.
Yes, all knock on wood. That's good, yeah. Yeah, because I have been trained, I can't take credit. I'm standing on the shoulders of some giants, dog.
That's good, man. Each one teach one, man. I love that, yeah, for sure.
These dudes taught me. So I want to just run this stuff by you. What else would you want to share with my Roundup family regarding going to court and dealing with tenants and winning in small claims court?
Yeah, just preparation is the biggest thing. You don't have to go this far, but sometimes I look in the mirror. I mean, just to make sure I feel confident in my approach, to where I'm not like fumbling over words and your documents. That's a major thing.
You say practice your presentation.
Yeah, I mean, if you want to go that hard, it means that much to you. Yeah, practice what you're going to say. I mean, you have an outline, just go through it once or twice and just say what you're going to say out loud. If you want to take it to the next level, have your family hear you say it, and then how you're really putting in work. And then when you get in there, It's gonna be an easy day. Your documents, make sure that they're at your fingertips. So you have these leases, these ledgers, you have things you want to show the judge.
Text messages, emails.
All of that. Just make sure you have them put together properly where you can just grab them right there so you're not fumbling over documents, things of that extent, paper clip it. Make sure you have these things paper clipped so you can hand it to the judge, have your copy, have a copy for the court, and even if you want the next level, have a copy for them so they can't say they didn't see it. Like, here's yours. Judge has his, and I have mine, and we're all talking about this document, so you're getting towards that preponderance of the evidence or clear and convincing evidence if you're in that scenario.
Preponderance. So when you go into court, y'all, I can't stress enough. And Jeremy, in my opinion, in my observation, it's easier to win because you've set the bar so high, exactly. And when you show up, it's like,
yeah, it's almost like the preparation is doing the work for you when you're in there. You done already wrote it all down, everything's there. You just following what you prepared, and then it's just you're getting points each time, and you're done. And if it's done right, they really don't have nothing to say. Now there might be something argument on their end, but if you covered yourself, most of the time, landlords there's no excuse for you guys not to be covered because you walk into the game knowing what's going to be needed. You have your documents prepared. You gave them their tenant's assertion, you take the tenant's rights forms, and they have everything that they need. So it's like you just going in there. It should be an easy day. It shouldn't be any problems.
It usually is for landlords.
Yeah.
It usually. I will say that. I don't like leading with that.
Yeah. It should be. Theoretically, it should be. But things happen. But it should be.
So speak clearly, y'all. Mm-hmm. Take your time. And I like what you said, Jimmy. Go over the stuff before you show up in court. Why not? Yeah. I do. I didn't want to put that on everybody, but I'm like, look, I'm doing this. I got my story. I remember this. It was this time. I remember that. But boom, wrote down.
Yeah. And you're prepared. And it's going to be an easy day because it's going to walk you right through the whole presentation. All
right. And worst case scenario, then you got to call Jeremy.
Yeah. Worst case scenario, you don't want to do it. Landlords, they have a lot of stuff going on. I'll let the lawyer, we'll handle all that for you. You know how to get in touch with us.
We'll put your information in the video show notes.
Yep. And then also if there's bigger issues like contract disputes, those big things, somebody didn't do what they were supposed to do, those larger amounts that hit you to circuit court, anything over that $25,000 mark, I recommend getting a lawyer there because then you're dealing with discovery issues like interrogatories, depositions, motions being filed. You don't want to get all up into that. So I would recommend highly there. And then,
Could we just stay at deposition for a minute? Because them joints are brutal.
Yeah.
Explain to my roundup family that doesn't kind of understand.
So a deposition is a statement that's taken underneath oath. So it's kind of like you're in trial, but you're not. You're sitting in an office somewhere with the lawyer, the other side's lawyer, and they're asking you every single question that they want to ask you in the world. And sometimes it can be objectionable, like it's not relevant, but you still got to answer it. So you go into the ones that they know they're playing the game right, they're going to ask you everything they can ask you just to frustrate you. It might take you 2-3 days to go through a deposition on a big enough case, and you're just there.
Days?
Yeah.
Wow.
But then underneath oath, so when the trial comes, you don't remember what you said in the deposition, they're going to be like, did you take a deposition in this? And you're going to be like, oh yeah, I did. Well, isn't it true you said this on this day? You're going to be like, I might have. And then they hit you with it and you're like, oh, I did say this. So, so that level, I recommend highly to always have a lawyer involved. Yeah,
were you lying then, or are you lying now?
Are you lying? Which one is it? Which one is it? And now nobody wants to believe what you're saying. So yeah, be careful with those. Those levels, it gets a little tricky, man. You want to have a lawyer for all of that. And even the lower ones, I recommend, but sometimes you might have practice with your family, got all your stuff in line. You might not need us for that stuff. Yeah.
Were you lying then, or are you not? That's all. I have been in these depositions. It's just not cool, man.
Right. When the lawyer pulls that question out, he's going down the right road for himself, right? Because it's like, it's really like, what are you saying? We don't need to answer for it.
You are done, y'all. So get with Jeremy. So up to $5,000, 25, maybe 25 grand.
Yeah.
The numbers are getting skewed. So we want you guys to be triumphant and do good, do right.
Yeah, do right.
Truth.
And the bottom line, remember, we're all civil. We can work this thing out, or you can work it out without even having to call me or going to court.
Yeah.
That's the name of the game, man. Let's work this thing out, both
Everybody
sides.
Wins.
And somebody might have to swallow a little bit of vinegar, but we're moving on. And then we move on. We don't have to go through all this. But just know that's always the best route, trying to work these things out.
Thank you.
Yeah.
All right, attorney Jeremy Mason, guys.
Yes, sir. Yes, sir.
I appreciate your time, brother.
Likewise.
You guys subscribe, like, but the main thing I need you to understand and I need for you to do for me is to share. We got to share this stuff with our community so people go to court. They don't sound like crazy men like what I be seeing when I go and I'm like, dude, Jeremy, I feel horrible.
Yeah.
I be hearing, I'm like, the judge doesn't, and you know the judge got his, I be like, I know the judge has his personal life going on.
Yeah, it does, right.
He can't just cut it off.
But those are the people that don't practice, don't prepare, don't have their documents right. So they think it all looks good on TV. Like, I'm gonna go in there and say this. I got it all mapped out. And then once they start talking, it's like, oh no, you gotta maintain this conversation. Where are you gonna go next? They just out there. They're just throwing stuff everywhere. So yeah, be prepared, people. Regardless of what side you're on, just be prepared so you're not wasting anybody's time. And we're getting down to the issues and we're all moving on.
I'm glad you brought that up because the stuff you're seeing on TV, that I've been in the audience of those TV. Judge Mathis is my guy.
Yeah.
But they want the people to kind of waste a little bit of time. That's what they want them to do.
Okay.
They're like create a story. They want to have a little.
bit of fun. I mean
that's
for the TV. Yeah, that's for the ratings.
But this shit here,
nah. In and out, succinct. Let's keep it moving because you look, there's people behind you. They're not there just to watch you.
30 people.
Yeah, they have their own business to take care of.
Yep. All right, class. We'll see you on the next video. Peace.